So let's talk about the recent changes in Florida law. As of March 24th, 2023, Florida Governor Ron DeSantis signed into law personal injury reform. Now there will be several huge changes to the way we do personal injury law going forward. Medical bills at trial. There has been a huge change with respect to admissibility of medical bills at trial. In the past, it was possible for the injured party, the plaintiff, to board all medical expenses no matter what the source that paid for it or how much they paid on it. So for instance, if any insurance company pays on a medical bill, it's usually a reduced amount, and then there's an adjustment, and then there's a balance. Well, that would be pennies on the dollar of the actual total value. Well, at trial, you would board all of the expenses, and then on the back end, the courts would reduce by the amount of insurance that had been paid, etc. And then that would give the total amount. Now, of course, those medical bills that are admissible will be based on the insurance payment, etc. So this is very duplicitous in my opinion, that now we can talk about insurance at trial, where in other forms or other ways we can't talk about it, in particular whether or not the defendant is being represented by an insurance company. Well, that can't be brought into evidence. But now we can bring it in with respect to medical bills, and rightfully so, because more bills were being boarded than were actually paid. Now, of course, what upheld this amount was the fact that there were letters of protection. And a letter of protection is an LOP that is almost like credit, that a medical provider will agree to treat your client when there is no health insurance or any more PIP available, and they will agree to treat them as long as they are paid on the back end. And what the Florida legislature has said is that they now, medical treaters, medical providers, have a financial interest in the outcome of the case so that they can get paid. And so because of it, now more information needs to be discoverable, including what the Florida courts had determined was attorney-client privilege, whether or not the attorney referred the client to a particular medical provider. Now that information is totally wide open and can be introduced in evidence. And how does that make an impact on a case? Well, instead of talking about the actual injuries that the client has and what the doctor did to treat those injuries, it becomes a sideshow talking about how much money the provider stands to make, and how this attorney has referred this client to you, and how many clients have been referred to you, and now it becomes a sideshow about whether the doctor is even coming in with clean hands, or whether they have good character or not, versus whether they did a good job on treating the client and treating the injured party or the plaintiff, and what the patient actually needs. And so that is a huge change, because now it puts a greater microscope on the relationship between the attorney and the medical provider. Of course, it makes perfect sense that an attorney would refer a client to a particular provider if you know that provider has a good reputation, does a great job. And now it becomes a situation where now no referrals can be made, because it's going to become discoverable in the future. It's going to be part of the case in chief, or for the defense in the future. So what do you do in that case? You allow the client to find a provider that they choose to go to, and allow them to choose their own provider, and then that won't become an issue. In addition, it becomes necessary to advise our clients not to sign LOPs, not to sign off on a letter of protection. Why? Because now it makes everything between the attorney and the doctor discoverable, when it is really not relevant, but for the fact that it's a sideshow with regard to the financial or pecuniary interest that the doctor may have, versus what the actual injuries are to the injured party. So that's another huge change to the law, that those medical bills will be reduced. And so even though get this, even though the medical provider will charge you a certain amount for their services, and they're allowed to, because this is capitalism, capitalistic society, you're able to charge what you charge for your services. However, the courts will only award a certain amount based on what the statute says. So whether that's 120 or 170% of the Medicare allowable rate, or whether that's the rate that the insurance company has paid, or whether it's the amount that has been previously paid, but not the full amount that was usually boarded in times past. So that's a huge change and update to our personal injury law, and how medical bills will be treated and letters of protection will be treated once you go to trial.